Thank you. So it's still morning, good morning. The next case we're going to hear is case number 20-22, the Department of Children and Families versus Child and Another. And in this case, of course, you all know that the case is impounded, and so we won't be hearing anyone using any of the parties' names. Okay, thank you. And
Morning. May it please the court, Sherry Krasner on behalf of the child, or really actually the teenager. My client will be 15 in a month. My client understands full well that the relief that we are seeking is dramatic and radical, but we assert that on the evidence as a whole here, that is what is required. Father was not fit to parent this child. Although it also wouldn't be radical in the sense if this court were to vacate the judgment and to order the return of my client to the temporary custody of the DCF in the United States. It's not so radical in the sense that father's rights would remain intact. He could visit her, contact her, do therapeutic work with her, all in the hopes that they could have a relationship as she matures into adulthood.
So it's been a year about since your client has been in Brazil. So have you checked in with her recently about her views?
Yes, I do, and my most recent conversation with her was on February 14th. And without going outside the record, we're here because that is the position that she still wants me to assert before this court. I've cited to the language in many briefs that quote about parental fitness and best interests not being separate and distinct, but rather cognate and connected. But really, it's in this case that concept really crystallized for me, what that phrase means. A parent can be fit in the sense that he is employed, stable, doesn't abuse substances, has no mental health problems, isn't violent or physically aggressive. But if that parent doesn't have the skill set that matches what the child needs and doesn't have it so much so that it puts the child at risk and jeopardizes her interests, her best interests, then a judge cannot find that parent fit. And that is what we have here. It's not a moral judgment.
I want to break this down a minute, because the department seems to be arguing that if the father is fit, then there's no choice but to have him have custody of the child. And are you disputing that at this point?
Well, what I am saying is that fitness isn't only those elements of...
That I understand, but you're not disputing this base proposition that if he's generally fit, then he gets to make the decisions for the child.
Well, that's axiomatic, but I guess I go back and say that fitness isn't just the surface elements. It's fitness to parent this particular child, and that's not a radical concept. That is what all the cases, the proposition all the cases stand for. Just here, there was such an extreme clash between what this child needs and what this father can provide that the finding of fitness just couldn't be made.
How do we distinguish, though, between what she needs and what she wants? Because that's, of course, the concern here that any parent would have. That, I mean, she really did not want to go to Brazil. We understand that. But, like, how do you distinguish that from his capability where, you know, he did go to therapy, but, for himself, he didn't necessarily need therapy, and he does have a home and a job, and he did actually maintain contact.
He went to therapy for 5 months, then stopped. When he was questioned about it at trial, he seemed to suggest that he was going, first he talked about, well, it was because I was deported, and then he said it was because the department made me do it. He didn't seem to have a true understanding of what he needed to work on in this therapy. There's certainly no evidence that he inquired about the child's particular needs. This was a child who was traumatized by her mother. If you read the record, mother's appeal is not before this court, but if you read about what this mother did to this child, it's heartbreaking and it's awful. And the child, she internalized all that. Couple that with the fact that she had no relationship with this man. He was out of her life by the time she was 2. And here, for a period of 3.5 years, They're having pretty regular and frequent phone calls and FaceTime, and yet there's really never a breakthrough in that relationship. They're not communicating with each other. She was willing to do the conversations more as time progressed, but there still was no bond. And again, I'm not here to make, my client's not here to make a moral judgment about her father or to make anything against him. It's just that the relationship just wasn't there. They weren't able to build it. And if they were not able to do that, it's just simply not possible on this record to find that this father was fit. And it's,
I think the
as the
father-
expert said,
I think the father might say, and certainly the judge said, you know, the problem was that the system disserved her. If somebody had sat her down and said, this is happening, so you really need to figure out a way to make a relationship with him, that it might have actually been a little different. But because she seemed to be getting information that if she just resisted, and let's face it, teens are very good at resisting, even the most skilled of parents, that was contributing to this situation.
But well, first I would dispute that there was evidence that she was getting information from others to resist. The record is quite clear that right from the beginning, when this petition was filed back in 2017, that she said she was not interested in going to Brazil. So that was before she was meeting with any other therapists, before she had counsel. She was saying that right from the get-go. And the other piece is she was in regular therapy. She got into therapy in 2018, and the therapist, not testified, but there's record evidence that the therapist said that she wouldn't even speak about going to Brazil. 3.5 years later, she still was resistant to the idea. And again, too, the child's expert testified this was not just a child, I believe he used language that it wasn't just a general childhood fear about leaving what was familiar. I mean, that we could all understand, this idea you have to pick up and go somewhere else. The therapist said that was, the expert said that was not just what it was for this child. It had to do with that, was the language he used, about the huge volcano of distress inside of her from her traumatic experiences with her mom, and that without the support of the community that she had always lived in, those familial supports, that the child would fall apart. So it's more than just, oh, she doesn't want to go, she's a teen, if dad says yes, child says no, that there was something about this child and her background, and father he just never got it. And again, I keep coming back to this.
But we can't reweigh that we don't substitute our judgment. So what I'm hearing you is, I hear you that you're saying that the father was unfit to parent this child, but I'm not getting what's the best case here, because what I'm hearing is she had a huge volcano of distress and he didn't show insight into how to deal with that, and they did 3.5 years of Zoom and there just wasn't a bond.
And I think that, again, we're not saying terminate this father's rights. I mean, I think if I was trying to make that argument, it would be a different argument. I'm not making that. I'm
More
saying
than what I just said, though? Is there more that you could say say that he's unfit to parent this particular child?
Well, I think another problem in this case, another way I can answer this question, is that the judge here was so convinced that this father was fit, and he made that determination before the close of the evidence, that I think that this court needs to consider that too. For this judge on the record to say before the department put on its case, to say, well, aren't we just here to talk about a transition of this child to Brazil? And this father is fit, why are we here arguing about this? And the action plan that the department provided to the father was ridiculous. I mean, these are things that the judge said on this record before the case concluded that I think should make this court feel as if this wasn't a fair trial.
So you're saying he was predisposed, is your point?
I'm certainly arguing that, yes, and that's...
I have a question for you. When the judge in his findings goes through the Chapter 210, Section 3 factors, there's one he talks about, this is at page 100 of Volume 1 of the RA. One of the factors is because of the lengthy absence of the parent or the parent's inability to meet the needs of the child has formed a strong positive bond with the substitute caretaker. The bond has existed for a substantial portion of the child's life, and the forced removal of the child from the caretaker would likely cause serious psychological harm. And the judge then finds this factor is applicable as it relates to mother. But the judge doesn't apply it to father, but throughout the rest of the findings, the judge acknowledges that the bond between the child and the father is weak. Are you saying that that's a place where the judge erred?
No, because the 210 Section 3C factors only apply in cases where termination of rights is before the court. And he was terminating mother's rights, but he was not terminating father's rights. So that's why he would not have addressed it, and why I couldn't
So it's all unfitness?
Correct. This is just a care and protection. It's just about whether at the time of trial, this father was fit, given the lack of the bond that he hadn't been able to establish with the child, given that he didn't show insight into the child's needs, and also that he was unavailable for this child in the sense that he couldn't come to America to meet her first, to pick her up, to do therapy with her. The deportation order had expired, but he feared coming to the United States because he had warrants, he could be arrested. Those warrants had entered years ago. He still had not addressed them. He testifies on the record that...
What about the Posey case that the department cites?
I'm sorry, Your Honor?
What about the Posey case that the department cites?
Right, because that is relevant if this was a termination case. It is true, if this was a termination of parental rights case, and the only issue was that he was unavailable because of the deportation order, then the judge would have been correct, that that would not be a reason for finding him unfit to the extent that his rights should be terminated. But I circle back and keep repeating that this was not a termination case. This was just a case about whether in August of 2021, this father was unfit to parent
What do you
this
say
child.
about the absence of other alternatives at that time for the child?
But that's not, I would say that wasn't true. That 1 month before trial began in June of 2021, the area clinical team for DCF had convened, and they were seeing what the child was seeing, that she was so resistant to going that it simply couldn't be in her best interest to force her to go. So the area clinical team was saying, well, let's do concurrent planning. We'll still try to reunify this child with her father, but we'll also see if we could achieve permanency through through guardianship. And there was a maternal aunt who was available, and that's it's in the third volume of the record appendix at page 15, where the team says, well, maybe we need to be thinking about something else because it just isn't working. And the judge comes out rather harshly and talks about, well, you're fouling up this plan, and why are you doing this at the last minute? But it was really that the department was saying, we see how it won't be in this child's best interest to force her. We've done all this work with her. She's she's resistant to going. We need to be thinking outside the box and have these two tracks for this child.
So you talk about the father's possible inconsistent statements. So I want to leave the earlier statement aside. He's testifying at trial. I left this then 2-year-old with a mother that was suffering or living with substance use disorder and prostituting herself. At some point, is that just the end of the game for him then? Because he just already left her. So, or is there some other argument you're making?
Well, that's what he says in 2017 and repeats in 2020. 21 at trial, but back in 2010, when this event actually happened, he had the opportunity then to get his child in a safe place, and he doesn't say that. He says this mother isn't using drugs. This mother...
Right, but I'm trying to figure out what even if you leave that aside, like, it seems fairly significant that if he's telling the truth at trial, he left a child in a very, very bad situation. Does that bear on his fitness?
Of course it does. Of course it does. And I see my time is ending. Again, the relief that we most ask this court to do is to vacate the judgment and order the return. But alternatively, we argue that the case could be remanded to a different judge, at which time a new motion for review and redetermination could be heard. And I thank the court for its time.
Thank you very much. All right, Ms. Kaiser, you have 10 minutes. You're splitting your time 10 minutes and 5 minutes,
Yes.
is that correct? All right, thank you.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the appellee father who asked you to affirm the judgment granting him custody of his daughter. This case may have emotionally difficult facts, but the law is quite straightforward. In fact, it involves two bedrock principles of care and protection law. And the first one is that a natural parent cannot be deprived of custody absent clear and convincing evidence of unfitness. And that is true whether it's a termination case or a care and protection case. It is not the case that you can sort of be unfitness light or something along those lines so that, well, we're going to keep the child in the custody of the department, but you can still have a relationship with her. There are times when a parent may be temporarily unfit, but that's not this case. The second important principle here is that the trial judge's findings of fact and conclusions of law cannot be overturned unless there are clearly erroneous findings or there was an abuse of discretion, and neither exist here. So I do want to speak...
I don't mean to interrupt you, but that's a correct standard, yes. But what do we do with, in this case, the repeated admonitions of the judge towards DCF and blaming DCF for how this whole situation has now developed? And the potential for inferring from that is that really influenced the judge's decision here, that the fact that the father had not been treated appropriately, much more could have been done earlier, and that was a factor that was...
So there's no question that the trial judge was quite frustrated with the way that the incidents evolved in this case. That being said, when you're looking at the snippets of colloquy that Child cited, you have to look at them in the context of this case. This is a very odd case procedurally because DCF is not asserting unfitness on behalf of the father. There are several times in the transcript where it says, no, we're not arguing that the father is unfit. So the court, and saying repeatedly that its plan is reunification. Its plan seems to be reunification, but just not now. That's not an option if the father is fit. So when the judge is saying these things about, well, the only thing that we're looking at is what the plan is going to be, and I want the parties to get together and make a plan, he's not prejudging the case. He is looking at what DCF's legal team is telling him, that their plan is reunification. And I think if you look very specifically at the exchange between the court and the attorneys at that point, you'll see this is not a case, he says several times, if the father is fit, right, or not found unfit. He doesn't say, I've already decided. This is not like a case like adoption of Tia, where the judge mid-trial says, look, I think maybe it would be a good idea if you folks settled. Therefore, kind of signaling, like, I'm going to find unfitness here. This is just a case where the odd circumstances affected what the judge said.
How does the standard of review, how does the judge then consider the best interest of the child? Granted, of course, if the judge finds that the parent is fit, and let's say there's no clearly erroneous findings, and et cetera, the judge could still have found, nonetheless, natural parent, deprived of custody, even blaming the department. The father is not unfit, but it's just not in this child's best interest to go to a foreign country where she's never been and doesn't even know the language.
Well, several things there, Your Honor. Unfitness and best interests are indeed connected, but you can't. But this is not like a probate court case where a mother and a father or two parents are arguing, where the standard would be a straight best interest analysis. The requirement is parental unfitness so that the parent is unable to further the child's best interest. And I want to speak to the question of, well, is the father fit to parent this particular child? So that argument is based on the unfamiliarity that between the parent and the child that got created by the father's deportation when she was only 2 years old. That unfamiliarity is not unfitness. The juvenile court regularly approves, and this court affirms, instances where children are to be adopted by complete strangers. And oftentimes, the department's plan for those children is recruitment, so that the person's identity...
When the child is this age, and this child can articulate her feelings, isn't that generally the case when the children are much younger?
Well, Your Honor,
I can't think of a case in which there's been a child at this age off the top of my head. Maybe you have one.
You know, Your Honor, I actually lost a case before this court where that was the exact argument, that children of this age should not, they should be able to say, I don't want...
You had a good argument. I don't understand.
Well, I thought so. but unfortunately, the panel didn't. But I think, what are we going to be looking for in a case, and again, it's not the father's burden to prove his fitness. But if you look at what would you want in a parent in this situation, right? You'd want stability. Well, the father has a steady job, a home, a place where he can have, the child would have her own bedroom. She has a little sister that she can form a relationship with. The father has shown unswerving commitment to this child. There are many times when he could have walked away, and frankly, I think the record reflects that sometimes DCF wanted him to walk away, but he never did. And he showed the kind of persistence that we would all like to see with parents of recalcitrant teenagers. He always kept showing up. Even when the child refused to talk to him, he always signed on to those meetings. So And in terms of his judgment that the child should come to Brazil, perhaps that would be different. Perhaps you could challenge his judgment if, for instance, the foster home had not disrupted, but it did. And I think any parent from a distance looking at this child's life as in the custody of a government agency would say, this is going to be hard, but I'm going to do much better. And I think when you think about these things, there's no question that this is going to be a rocky transition. I'm sure it has been. The child has really been subjected to terrible circumstances in her life. But as the trial court found, and I don't hear any challenge to his finding that the father was willing and capable of providing this child with a stable home, which is something that she hadn't had for her entire life. So I think in those circumstances...
So what do we do with basically the father's trial testimony? Yeah, I left a 2-year-old with a drug-addicted mother who was prostituting herself.
Well, first of all, Your Honor, it's a very well-settled principle of care and protection law that stale evidence can't be considered, and that evidence from 10 years ago is certainly quite stale. even if the father made him, now, and also remember, the father was deported shortly thereafter. So his ability to intervene at that time, for most of the child's life, was because he was unwillingly deported from the United States and could not return until at least 2020, at which point the pandemic was in full force, and there was evidence on the record that it was very difficult to get a visa at that time, which is certainly understandable. So I don't think, is that evidence relevant? It's relevant, but it certainly falls very, very far short of the clear and convincing standard necessary to show that the father was unfit.
She argues his earlier statement saying, oh, everything was fine with mother, come in under 51B, not 51A. What do you say to that?
Well, Your Honor, I think, first of all, I think any argument on that was waived by the failure to present it to the trial judge. I don't think we can expect trial judges to comb through these DCF records, find an inconsistent statement, and just address it independently. But even if he did, that statement made for whatever reason, the father never was confronted with it, so didn't have a chance to explain the discrepancy, but that inconsistent statement would be insufficient to upset all of the credibility that the judge determined that he had.
So the child basically argues that despite these 3.5 years of Zoom calls, that the child and the father were essentially strangers at the time of the judge's ruling. Do you challenge that?
I think, yes, I think it's fair to say that they had not established a strong bond via the Zoom meetings, although it certainly was better than it was before that. However, it's a very difficult thing to form a bond over Zoom once a week if the child shows up when they're speaking different languages. I think parents don't need to be remarkable parents in order to be fit. They simply need to be adequate parents. I think the father showing up every week to be on that Zoom showed that he was willing and able to build a relationship with this child. So I see my time is up, and I would just ask you again to affirm the judgment.
Thank you very much.
Good morning. Lynn Murphy for the Department of Children and Families. This is a really unusual posture for the department to be in. The department was not thrilled with the determinations made by the trial court, but we do not believe it rises to the level of reversible error for the reasons I state in my brief. Since my time is short, I think I'd rather entertain questions from you than to reiterate any points I made in my brief.
So, I mean, the child's position basically is that he can be a perfectly fit parent generally, but he wasn't fit to parent her, that's what the evidence here showed. What's your response to that?
The judge was very impressed by father's commitment to this child, his early on involvement, the fact that he visited consistently, that he was able to testify as to what kind of services he was going to put in place. And while the expert certainly provided evidence to the contrary, the judge was not required to find that he could not meet those needs.
What do you say to the child's argument that Posey is distinguishable because that's a termination case?
Yes, that's true. I think the Posey case, what the judge was using it for was, well, he might have overstated what Posey stands for, but I think the point that we need to look at is when a person is deported, their ability to participate in services and do things for the child is restricted. And certainly in this case, we know that the father could not come to the United States until December 2020 because of the order for deportation. So the issue becomes, what did he do from December 2020 to the time of trial, which I believe was June or summer of 2021. And the judge felt that he had shown, again, his efforts were more than sufficient to show that he did try to cooperate with the department, he did what he needed to do, and there was no clear convincing evidence that convinced this judge that he was unfit.
Well, he didn't learn English, right? I mean, he
He did
took some
not.
lessons, but he didn't learn it. I mean,
Right.
and she had complex emotional needs. So, I mean, if he can't take some basic English lessons and actually learn the language, which I'll grant you is not easy, how do we trust her complex emotional needs to him?
Right, again, the judge heard all that evidence, and he knew, the department did bring that forth, that the father had only, I think he had only participated in a few YouTube videos or some kind of virtual. And we pointed that out to the judge, but the judge was not, the judge felt that the department erred by not putting the child in Portuguese language classes earlier. The judge was definitely very unhappy with the department in this.
Do you think the department learned any lesson here about if the parent and the child don't speak the same language, that right off the bat, the department should be having both of them try to learn the other's language?
I think the department really did try to
I know,
help.
but I'd like to know that we're never going to see this factual scenario again, where years go by and nobody's learning anybody else's language.
Yes, there definitely could have been better. I definitely think the department made many efforts and definitely tried to work with a child that was traumatized. The department was very concerned about this. And to force a child, we only have so much ability. Child didn't want to learn Portuguese. That doesn't mean we couldn't have done more. We tried to put the intern, the Portuguese-speaking intern there for visits. We tried to supervise these visits to help with that. But could we have done a better job? Of course. We could have
What about this
tried earlier.
I'm perceiving a tension that maybe doesn't exist in the case law per se, but in applying these two principles to this case seem to be a tension, which is intention, which is that whether or not a parent is fit and what is in the best interest of the child. Because if we are to agree, hypothetically, there's no question the parent here is fit with respect to the factors we might consider and the judge's findings. But we could also hypothetically find that this was not in this particular child's best interest to be subjected to this huge upheaval in her life at this point in time. How do we reconcile those two principles?
I think the problem is, once the judge was so adamant that this was a fit parent, that's really the end.
So that supersedes the best interest of
I'm
the child.
afraid so. But what would have been the department's preference, I think the trial attorney could have done a little bit better job in packaging this for the court, but could have found temporary unfitness. And then at that point, because in its essence, when you read this whole record, you can see that's what the department was saying. He's not quite there. We're not saying he's unfit, but we have more work to do with this father. So it's, I don't know, maybe it would have made no difference at all because the judge was very, very strong. But I think if you look at it that way, he has a lot of potential. There's a lot of great things about this father, but at this point, he's still temporarily unfit, and therefore, we can consider the trauma that the child will endure in this transition, and that would have been...
Thank you for your answer. I see you're over your time. I'm just going to...
Oh, thank you very much. No
All right.
further questions.
Well, all these cases are difficult. They're always difficult, and I speak on behalf of myself when I say this is one of the most difficult ones I've seen. And this month I've been on the bench 17 years, and so I guess that says a lot. So we'll take the case under advisement, we'll give it our close attention, and we'll do the best we can. Thank you. All right, we're coming up to our last case that we're going to be hearing this morning. The number is 2022-0605. Name of the case is Trustees of 10 Porter Street Condominium Trust versus Elizabeth Serta and another. I understand we have an interpreter in this case, and we're going to begin by swearing in the interpreter. And
Could you identify yourself for the record, please?
Carla Crispin.
Grisby, do you solemnly swear that you will faithfully and impartially interpret all statements by the court, counsel, and the litigants in the case now pending before the Massachusetts Appeals Court to the best of your ability, so help you God?
I do.
Thank you. Just a moment, and we'll get everybody settled, okay? All right. All right, so the two of you can sit right there. All right. And if anybody has any difficulty, you'll be sure to let us know, all right?
Okay.
Okay.
Okay, wonderful. All right, you have, Mr. 11 minutes for your argument, is that correct?
Yes, that's
All right.
correct.
Please, go ahead.
Good afternoon, may it please the court. My name is Elizabeth Serta. I'm one of the pro se defendant appellants in this appeal. As you know, our appeal encompasses a number of issues, questions of law, findings of fact, and obviously we also take issue with some procedural matters that the court decided. I'll begin with the questions of law. It is our opinion, or our belief, that the court erred when it decided to implement Rule 2, a rule for the general common areas, and apply that to a limited common area, specifically Ms. Burgess's exclusive balcony.
But
which is-
just so I understand, Judge Karp ruled in your favor as to the cameras, the two cameras in your unit, and ruled that you do not have to pay any fees or fines.
Correct,
So you won.
correct.
So you personally are not appealing. I mean, what is your argument on appeal? What relief can we give you on appeal?
Right. So I'm appealing because, well, for a number of issues. I disagree with the findings of fact, specifically with the finding that the trustees and their counsel did not, or Judge Karp found in his findings of fact and rulings of law that the trustees had acted impulsively in fining Unit 1, despite the fact that there was no basis to fine Unit 1. I disagree with that finding, and I would push the court to find that the trustees, together with their counsel, acted in bad faith against my unit, and not only did so in fining my unit, but did so in committing perjury during the evidentiary hearings. So in my brief, I highlighted Mr. Donahue's perjury in stating that my cameras were in the common areas. If you remember, the invoices that the trustees issued against my unit indicated that my cameras were in the common entryways, which they were not.
But the judge disbelieved that, or found that not credible.
Right, so then my point is, if they lied on the statements, if they lied at the evidentiary hearing, and he still tried to act as though they believed that the windows were common areas, even though the master deed clearly designates them as belonging to the units, and Mr. Dunn, who is the majority beneficiary trustee who owns 70% of the condominium, can't even tell me on cross-examination where my cameras are after 5 years. That's not acting in the interests of the condominium. That's not acting in good faith towards me as a unit owner. If they didn't have a basis to fine me? Why file a collections action? Why go through this action over 6 years?
Okay, but assuming we agree with you that the evidence really established that the trustees acted in bad faith, what would you get from that?
Well, we have moved the court for our, I'm going to say attorney's fees, but it's not attorney fees because we are pro se under Chapter 231, Section 6G. That finding of bad faith would be necessary for that. There needs to be a frivolous action. There needs to be bad faith on the part of the trustees. I think we're entitled to that given that they didn't have a factual basis to fine me and certainly didn't have a legal basis to fine me. And I've had to defend myself from their actions over the past 6 years now.
So you're saying attorney's fees for the underlying actions in the court below or here?
I would say both.
Okay.
So I don't, again, the other issue too is that their attorney, and we're moving towards the attorney's fees, which are also part of the issue, Attorney Turkey presented affidavits of counsel to the court that said that my mortgage bank, Salem 5, had only paid about $500 in attorney's fees in 2017, pre-judgment. That's not true. Correspondence from the bank to counsel's co-associate revealed that, in fact, the trustees demanded $3,700 in attorney's fees from my unit and from Ms. Burgess's unit, and $3,700 in attorney's fees, plus 500 something in condo fees. So in effect, when the court determined that I didn't owe any condos fees because the fines were illegal, it did not include that amount in its calculation. It did not determine what I overpaid in attorney's fees, for that matter, because again...
You want that money back?
Yes.
And does it go to you or to the bank?
Well, the bank paid the trust and then charged us. So I had to pay the bank. So ultimately, it came from me indirectly, but we did end up having to pay that. But yeah, going back to the bad faith, if the trustee who has given his continuous vote of approval for these actions can't even specify on the witness stand where my cameras were, if they were inside, outside, he was clueless, and I included an excerpt of the transcript there. That's not good faith. That's not acting in the legitimate interests of the trust. There's no legal basis or factual basis there. And then if we look at the testimony against Ms. Burgess, Mr. Donahue alleged numerous times on the witness stand that Ms. Burgess had drilled holes into the building to run the wire from the camera on the balcony into her unit. And yet he couldn't point out where the hole was. And this is for the first time in 5 years that they're alleging this on the witness stand. I asked him what surface. Is it the brick surface, the glass, the wood, the metal? Couldn't say. And as you know, Judge Karp found that that's not true. There were no holes drilled to run the wire. The wire was run through the window, which was left slightly ajar. So if that's not bad faith, I don't know what is. If he's committing perjury on the stand, he's defaming Ms. Burgess here on the stand, abusing his role as trustee to effectively perpetrate abusive process against us. I'm going to remind the court that we have an action in Superior Court in Lawrence, Serta versus Dunn, where we are alleging abusive process against the trustees. And skimming over to the issue with consolidation, you know, the court should have consolidated these actions, the hearing, the evidentiary hearing for these lien enforcement actions together with trial for Serta v. Dunn. Both of these actions are dealing with the legality of the fines.
And is the advantage to you of consolidating that perhaps some of the award against, or at least your mother, of charges and fees was there might be some offset then?
No, the disadvantage is that now we've had triplication of proceedings. So we have this action, these actions here. We have Serta v. Dunn in Superior Court. And by the way, trial for that has been postponed yet again pending resolution of this appeal. We also now have a district court action that the trustees filed against Ms. Burgess in July 2022, seeking new fines for the camera on her balcony, for which they never served invoices upon Ms. Burgess. And so now we have appeal here, a trial that's on hold in Lawrence, and another trial that will be forthcoming in district court.
So there's a new action?
Yes. They appealed this judgment and then filed a new action against Ms. Burgess. And the Superior Court has stayed trial in our action against the trustees, but did not transfer the district court action to Superior Court, which in my mind, again, judicial economy, consolidate the actions, and have one trial. Why should Ms. Burgess and I have to go through all of these proceedings? We don't earn money to be here. Mr. Turk does. Why should we have all of these different proceedings to deal with one issue, whether these fines are legal on the balconies? Do you have other questions before I continue?
I have a question. At the evidentiary hearing in January of 2022 before Judge Karp, after the trustees rested their case, and Mr. Dunn was on the stand, and you were questioning him about how exactly it is that the cameras violate the condo documents. And the judge excused Mr. Dunn from the stand and then began questioning the trustees' counsel about where exactly in the condo documents it says cameras are not allowed. And as I understand your brief, you're arguing now that that was prejudicial to your presentation of the case for the judge to interrupt the flow of your questioning of Mr. Dunn. But where the judge found in your favor, and at a couple points he said to you, you're not helping yourself, can you just let him speak? Let me tell you what my thinking is so you don't steal defeat from the jaws of victory. And he ultimately ruled in your favor by saying that your cameras did not violate the condo docs. So how is it that you're prejudiced by the judge not letting you be the one to bring that out of Mr. Dunn instead of him?
Right, so there were numerous instances during the trustees' case, during examination, where I wanted to elicit certain information from the trustees. And I was told numerous times, you'll be able to do that during your presentation of the case. However, I was deprived from the opportunity of presenting my case. I was even interrupted during Dunn's examination. I would have been able to demonstrate bad faith right then and there had I not been interrupted by the court.
And that would have given you a better opportunity to seek attorney's fees, is your point?
Correct.
But you don't have attorney's fees.
No, but under Chapter 231, Section F, I believe, 6F, if these actions are frivolous, I would be entitled to be compensated as a pro se litigant for my time, for my effort in defending against these actions. So while I may not have an attorney, certainly this has taken up a lot of our time, a lot of effort. I mean, I'm arguing here as if I were an attorney, even though I'm not.
But you might consider it.
Yes, you're doing a good job.
And so let me get to that issue again. So Ms. Burgess and I are co-defendants in this action. Ms. Burgess is an LEP litigant. She has a little bit of a handicap therein. Case law doesn't come in Spanish. Educational materials don't come in Spanish. Often, Ms. Burgess has to rely on me, and that's not a secret. That's been the case throughout all of these actions, has to rely on me to understand the nuances of trial, the nuances of civil procedure, and things like that. I think if we communicated to the court quite clearly that I would be taking the lead in presenting our case in a consolidated fashion, and no, I don't represent her and I can't represent her, but nonetheless, our arguments are more or less the same. We have the same grievances, we have the same defenses. Okay, her cameras are on her balcony, but as a unit owner, I also would be interested in establishing that the trustees don't have a right to tell me that I can't have personal property on my limited common area balcony. My unit has a limited common area balcony as well that's assigned exclusively to my unit.
Is that term limited common area in the condo doc somewhere?
It's recognized by the statute, the condominium statute, so Chapter 183A, Section 1, I believe.
I do see you've used up your time, which is one of those things that's a problem for every lawyer and pro se litigant that come before us. And we have actually some questions, but let me just see if there's any follow-up that we need here. We don't, so I'm afraid you're going to have to rely on your brief. But we will now hear from Ms. Burgess, who does still have her full 4 minutes.
Thank you, Your Honors.
Thank you. All right, we just want to be sure that we can record, one moment. We want to be sure that we can record your translation. So will you be using the same microphone that Ms. Burgess is using? Is that all right?
Yes, Your Honor.
Okay, thank you. You may proceed.
Buenos días, como dije. Estoy aquí para volver a decir que esto es un abuso grave.
Good morning, as I said, and I return here to say that this is a grave abuse
Y una negligencia grave también.
and also grave negligence as well.
De parte del abogado de la asociación y de abogado personal de los trust team,
And this is in part of the attorney for the association and also the personal attorneys for the trustees.
que de hecho ya es un conflicto de interés,
As a matter of fact, there is already conflict of interest there.
porque no sé cómo va a defender a la asociación y a los dueños, a los otros al dueño de las otras 4 unidades.
Because I don't know how is he going to represent the association and then the owners of the other 4 units.
En el caso evidenciario que tuvimos en Ceylon, no se me permitió presentar todo mi caso.
In that case we had for evidence in Salem, I was not allowed to present all of my case.
Terminando esto en algo que no fue bueno para mí, sino perjudicial.
This ended in something that was not good for me. It prejudiced me.
Porque el juez determinó que yo debía pagar parte de las multas de las cámaras, de la que está en el pasamano de mi área común limitada.
Because the judge determined that I had to pay part of the fines for the cameras that I had in those the limited areas that were common.
What part of your case were you not permitted to present?
¿Cuál parte de su caso no le permitieron presentar?
Toda la evidencia que tenía de los abusos de los inquilinos de las otras unidades,
All of the evidence that I had of abuse of the other tenants in the other apartments.
que han violado todas las reglas, y el abogado
They have violated all of the rules, and the attorney
de la asociación nunca le ha puesto una multa, y se lo puede preguntar, ni sancionado, ni le ha puesto un caso en la corte,
The attorney for the association, and you can ask that attorney, has never fined them, has never given them any other sanction.
So when you say they, who do you mean?
Cuando usted dice a ellos, ¿a quién se refiere?
al dueño de las 4 unidades que tienes inquilino, porque ellos no viven ahí, ellos tienen inquilinos que hacen todo lo que quieran.
To the owner of the other 4 units who does not live there. They have tenants, but they do not live there, he or she, the owner.
Ellos nos pagaron los condo fees por las 4 unidades por 3 meses.
They did not pay the condo fees for the 4 units for 3 months.
Cuando se puso el assessment especial,
When that special assessment was brought about,
nosotras no los pagamos,
we did not pay it.
pero ellos tampoco los pagaron hasta la semana misma que ya me iban a poner el link, condenarme a mí y a la señora Cerda.
However, they didn't pay it either until that same week when they were going to put the lien against me and against Ms. Cerda.
Presentó un cheque con la fecha que debía haberlo depositado,
They presented a check with a date on which I should have deposited,
pero nunca estuvo en el banco, nunca estuvo depositado en el banco de la asociación,
but it was never deposited in the bank for the association.
que es lo mismo como que nunca pagaron hasta esa fecha.
It is the same thing as they having not paid up until that date.
Ahora él ha empezado un nuevo proceso en contra mía por no pagar lo que decidió en el proceso que tuvimos,
Now he has started a new process against me because of what I did not pay,
por la cámara que estaba en el pasamano y otra nueva que yo puse.
because of the camera near the handlebar and the other camera that I installed.
I'm
Él
gonna
está
interrupt you.
demandándome.
Excuse me. I'm going to interrupt you for a moment to let you know that your actual time for argument is finished. Yeah, when the red light is blinking like that, it means your time is up. Is there anything, one last thing, one final comment you would like to make to us before your argument is over?
Comentario final que nos quiera decir antes de terminar su argumentación.
Ellos me están demandando a mí por la cámara y Y hasta me pusieron otra demanda. Pero ellos pusieron la misma cámara en el mismo pasamano.
They're suing me for the camera and then for something else, but they placed cameras in that same area.
En la unidad número 2
It was in unit number 2.
Okay.
y una más en el área común que no es limitada.
And another one in the common area, which is not limited.
Okay.
Pregúntele al abogado si él lo ha sancionado, si le ha puesto multa o le ha puesto un caso en la corte.
Ask the attorney, has he sanctioned them? Has he fined them? Is there a case against them in court?
Okay, thank you very much.
Thank you.
Thank you. Thank you both very much for your arguments. Well, do you want to start by answering that question? Whether or not other people have also been sanctioned for similar activities?
Your Honor, no one else has a camera in the common areas or attached to their windowsills. So no one else has been fined because no one else has violated this rule. But I think that's not the issue, Your Honor. And I think to start, Your Honor, good morning, or good afternoon now, Your Honor. My name is Jeffrey Turk. I represent the Condominium Association. May it please the Court. Your Honor, this case is on remand. There were three very narrow issues that were remanded back to the court, and none of them were the issues that were brought up just now. Three issues. One, the basis for fines and legal fees. Two, the legal authority to assess fines and late fees. And three, the issue of whether or not we violated Judge Howe's, our representation to Judge Howe to maintain the status quo during the pendency of the continuance on the motion for summary judgment. Just to start with that issue, Your Honor, the third issue, I think the judge made clear, he reviewed the entire transcript in context, and it was clear that the representation that was made to the court was that we would not change the status quo in relation to ownership of the property, and that was the issue that was raised by the judge. The judge was looking at the issue of irreparable harm. They were claiming that somehow they were going to lose the unit if an injunction did not issue to stop the case, and we confirmed with the court that no action would be taken to affect their title to the property during the pendency of the case. We were very clear throughout that hearing that the fines would continue to accrue until they simply removed the camera, which would have stopped all of this if they had just taken that simple action. So in relation to that first issue, I think the judge made clear findings based on his review of the entire record that we did not violate that representation to the court. As to the second issue that was remanded, whether or not the association had legal authority to assess fines and late fees, I think the court's determination also was clear based on the clear precedent and the statute itself, which is Chapter 183A, Section 10B5, which specifically authorizes associations to assess levy fines and late fees. It's statutory.
Well, it says reasonable fines, though.
Correct, but
So what guidance do we have from case law or anywhere else about what reasonable means?
so I think in this case, Your Honor, the question of reasonableness was whether or not it was reasonable to fine these people for the violation, not the reasonable amount of the fine, because I think that would set a dangerous precedent if unit owners could do exactly what these unit owners are doing.
So you could fine $1 million a day?
Your Honor, again, I think you could fine $1 million a day if that was deemed to be reasonable by the court. Whether it was reasonable to fine for the violation, that's not the fact here, Your Honor. The fact here is $50 a day.
But the judge ruled that it was not reasonable to have $50 a day and that $10 a day would be reasonable. Why can't the judge say, my interpretation of the word reasonable in that statute is $10 a day?
Because if that's the way the court interprets this statute, that a unit owner can go into court and challenge the amount of a fine the amount is not reasonable, then every unit owner in the Commonwealth who smokes in their unit or gets fined for parking, gets a $50 parking fine, says, I don't think that's reasonable. I'm not going to pay it. I think it should be 10, Judge. We're going to then have the court being the super board, which the courts talk about its decision, become the super board. You'll come to court anytime you don't like the amount of a fine, similar to I got pulled over for speeding. I don't like the amount of the fine. I'm going to come to court and challenge that.
Well,
that's not what the unit owner can do.
In that analogy, everybody has the right to do that.
They have the right to come in and challenge the speeding ticket, not the amount of the fine.
Well, they can challenge both.
The fine is statutorily set for the amount. They can come in and ask the judge to find they weren't speeding. Judges often use sometimes discretion, but they don't change the decision of how much to fine. The same with a parking meter.
I think the point is, at some point, if the fine is grossly unreasonable, somebody has to come in and challenge that, right?
Your Honor, I don't think that's what the law says, because again, first of all, I disagree that you cannot pay and just challenge it, because that would flip the entire condominium trustee authority on its head. We would have unit owners and courts second-guessing trustees on the amount of the fines that they assess. And every unit owner would be able to come in and say, I don't think that amount is correct. Again, I think that's what the judge here did, with all due respect to the judge. He said...
You're saying they could say that if they paid it first, then they came in?
I think that they have to pay it first to come in, but a prior panel disagreed with that in this case. But I don't think also they can come in and challenge the amount. I think they can come in and challenge the reasonableness of fining for that violation. For example...
So when the legislature in 10b-5 said, and to levy reasonable fines, you want us to interpret that they really meant and to reasonably levy fines?
Well, I don't think the language is very clear, but the way I would read that is the reasonableness of the fine, not the amount, because again, I've never seen a case where someone has come through and challenged the amount of the fines that are being assessed.
Except for this one, which we've already done.
Which the judge did in this case, and that's what's on appeal. And again, I think this is a classic example. The judge just used his discretion. He didn't really do it based on anything. They didn't say, we think a reasonable fine is this. He just sort of decided, I know better than the board. I think to gain compliance, $10 would have been reasonable, not $50. Now, in retrospect, we know, and Ms. Serta admitted on the stand, that it wasn't enough because it wasn't going to change her mind. If it had been more, she said, maybe that would have made me change my mind. But again, I think that's at the foundation of the whole condominium form of ownership that the court has recognized, that we have to give deference to the board, and that's part of what you do when you buy into a condominium. You give up some of your autonomy to an elected board, a democratically elected board, who makes these decisions, and we have to give deference to that board. Otherwise, again, we're going to turn courts into super boards that everyone can come in and challenge.
Well, what do you do in a situation where it seems that the condominium board is acting, not treating everyone equally, not making everyone pay the special assessment? I mean, I thought in the prior decision, what did we say about that? I thought we said that was not okay.
Our courts have never said that a unit owner can come in and challenge selective enforcement. In fact, that's what the judge in this case found. Right? The issue is, did you or did you not violate this provision of the constituent documents? Right? And I would just ask the court to imagine if a unit owner could say, yeah, I've got a dog, but he parked his car illegally, right? So therefore,
but if I got a dog and he has a dog and you don't like me, and so now you're going to fine me and you're going to let that guy have a dog. Why is that okay?
Then your remedy is to get rid of your dog in compliance with the condominium documents and bring a derivative action claiming that the association is not enforcing their obligations, right? And I think in the Noble case, they talk about that.
Why is it your remedy to say, I'm perfectly fine with them not enforcing the dog regulation? We can all have dogs.
But that's not up to you as a unit owner. It's up to the trustees to decide that.
The trustee made a decision. They're not getting rid of that dog. You got to treat us all the same.
So you could go in and claim as a derivative action that is a breach of fiduciary duty, right? But you can't just say, I'm going to violate the rules because you're violating the rules, right? That's not what the statute says.
No, I think they're saying you're not enforcing the rules and that's okay. I'm okay with that. But you can't come at me.
But that's not for the two unit owners to decide that we're going to overrule what the trustees decide. Trustees decide, in this case, the trustees decided, for example, cameras in common area are not allowed. Cameras affixed to the windowsills are not allowed.
If I understand you, you're saying that if they just, say, took one of those buckets from a hardware store, filled it with cement, and put a camera on that, and put that on their balcony, that's perfectly okay, because it's not attached to the condominium. So they can have a camera. Your problem is you don't want it screwed into something.
No, Your Honor. The trustees, in their discretion, have said, we don't allow cameras in the common areas. Any camera in the common area, this one's affixed.
So they can have it So they can't have it on the balcony, but they could put it inside the window looking out. That would be okay?
They could put it inside their window as long as it's not attached to the frame of the window is what the condominium documents say. And this is not an uncommon issue, Your Honor. With Ring doorbells now, we have many unit owners who want to put Ring doorbells on the outside of their unit, right? They can't because you can't affix something into the common areas. Could you put that Ring?
You can have a doorbell, can't you?
You can have actually, no. If the condominium association documents say you can't put anything outside your unit, then you can't put something outside your unit, and the exterior is part of the common area. We have this all the time where someone says, well, could I put the camera inside my unit? Sure, you could. You can't affix it into the common areas. And that's what the condominium documents say, and that's what the trustees have said. And that's their authority to do here. They've said you can't put a camera in the common area. You definitely can't affix it to the...
So can they sit there holding a camera?
They,
on the balcony?
could they walk outside with a camera? Sure they could, because then again, they would not be maintaining it in the common area. They'd be walking through the common area. But they can't affix it there and they can't leave it there because that's what the documents say, right? And again, just to point out, those are what the documents, the original documents from long before these current trustees bought. Probably the worst thing they ever did was buy into this association, but these existed long before them, the original documents, and the Noble case says they need to be given great deference when they're the original documents. This isn't a case where they passed a new rule saying suddenly you can't do this, right? That would be against Noble. These are the original documents that say that. I did also want to mention to the court the reason why a new action was filed, and that is because the judge found that these fines only go through January of 2019, and so despite the court's ruling that the camera is not allowed, the camera remains, so we filed a new action based on the fines after that date, because again, the one thing that's within the only control we have here is that they could remove the camera, and all this would stop. And that has been said since the beginning of this case. Just remove the cameras, and the fines will stop.
Put them inside, or put them inside.
Or put them inside, and don't affix them to the window frame, which I think, just because my time is limited, I do want to mention the reason I think the judge's decision was wrong in relation to Ms. Serta, and I think it goes to Justice Walsh's point, which is the judge sort of made a decision before the evidence was closed that the cameras affixed to the interior of the unit's frame was not a violation. And I think that was an error because I think, first of all, the condominium documents are clear that you can't affix anything to the frame of the windows, that even while that is within your unit, the master deed says you can't affix anything onto those frames if it's visible from the outside of the unit.
So somebody couldn't put Christmas lights up, if you can see them from outside?
If they're affixed to the window frame, the answer is no. And the reason, Your Honor, is because if I decide to put Christmas lights up, for example, and then you decide to put up other lights, and you want to put up the Irish flag, and I want to put up this flag, you're affecting the architectural integrity of the association and the view from the outside.
So
And that's why, again, you give up part of your authority for your unit when you buy into a condominium, because we want it to look all the same from the outside. So here, the judge decided and sort of stopped the testimony that that window frame was not a violation to affix something to that. There was no dispute. Neither of these defendants dispute where the camera was, why it was there, what their purpose was. Their dispute is, well, it's not common area, which we know is not correct as to the balcony. And as to my window frame, I can install things there because it's within my unit. But again, there's a master deed provision that directly says, and it's really broad when you read it, it talks about not just awnings, but it talks about any type of fixture, any device.
So does that mean somebody can't put a lawn chair on their porch or a plant?
So it would if the trustee said you couldn't. And there are many condominiums that say, as to common area, not part of the unit, but common area.
The porch.
Right, which is common area. Many associations say what you can put out there and what you can't. For example, you can put a chair out there, but no grill. You can put something out there, but you have to bring it in every night. We don't want bikes out there. Associations all the time dictate what you can put out there and what you can't.
But what I'm asking is not what other associations do, but the language of Rule 2, nor shall anything be stored in the common elements without the prior consent of the Board of Trustees. Are you interpreting that to mean that if Ms. Serta or Ms. Burgess wants to put a lawn chair on their porch, they have to ask the trustees first?
If they want to store it out there, yes, absolutely. And in fact, what the judge found was that people did have stuff out on their porches, and the trustees allowed that, right? Allowed everybody to put some items out on their porch. But again, this just goes back to the basic concept, which is we leave it to the trustees to decide that. You know, the trustees could have decided nobody puts anything on their porch at all. We just don't think that is aesthetically proper for our association. They didn't. They said you can have normal things out there that a person would have on their porch. You can't have a camera. And that's within their discretion to decide that, and that's why trustees are imbued with authority to make these decisions.
So with the number of units that are in this condominium and the ownership, could they ever become the trustee? Is there any chance of that, or would it always be your client?
Well, they were trustees for a period. But when they bought in, they would have known they own 2 out of 6 units, so the chances are that they're going to never be elected trustee. In fact, you know, when we talk about the court cases here,
That's because your client owns 4 of the 6 units?
That's because other people have bought the other units. And that happens in every condominium, right? You buy in, you may be the minority owner. You may someday be the majority owner. But you know when you buy in, I only have this percentage. And some associations, you know, have 100% required for any decision for that very reason. This doesn't. This association, their documents say the trustees are elected and they vote. So
These documents need is a provision for mediation.
there is no doubt, Your Honor, that this case should have been resolved. I will just say there is a pending action. One of the parts of that action is whenever, and I think it's part of the record, there have been many offers. My client has said, we'll sell you our units, just buy them, we want out, or we'll buy your units. Like, we can't live together. Their position in the litigation is that that is a violation of their fiduciary duty, that it's wrongful, that's fraud. But I think every judge who's ever had this case has said this case should go to mediation and get resolved. And my clients are, believe me, the worst thing they ever did here was buy into this association.
Well, it's unfortunate all the way around, but we'll take a very close look at all the issues and the arguments, and we'll take the case under advisement and get back to you as soon as we can.
Thank you, Your Honor.
Okay, thank you. We're done for the day. Thank you to the interpreter for being with us today. We appreciate your help, and the court will stay in recess.
For all rise, please. Court is now in recess.